Who is that cat?
Archer.
You're just gonna stare at me? Oh.
I am rollers. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy to have you guys back on. As promised, we are going to watch the remainder of the Roger Hillygus hearing. But before that, I got a couple bits of news to break to you guys. The main one is actually going to be tomorrow's agenda. This morning, the Tennessee Supreme Court handed down an opinion upholding the conviction of a low-tier SovCit guru by the name of Christopher. Oh my gosh, what was this? It starts with an H. Christopher Hausen. Oh my god, I can't believe I'm drawing a blank here. He's definitely a low-rent SovCit guru. Not the biggest following like David Straight, for sure. Hauser, there you go, Christopher Hauser. So I'll give you the shorthand, but we're going to go through the entire opinion tomorrow. But I'll give you the shorthand. Essentially, he and a bunch of other colleagues filed millions of dollars in false liens against public officials in Tennessee. They were convicted, and Hauser himself was sentenced to 20 years. The others got like 25 years, 20 years, and another like 20 years as well. So these were like stiff sentences. They tried to get them overturned, and they lost. On top of that, their liens were also in relation to another SovCit that we actually covered before. It involved a Tennessee individual, but I will save the remainder of that for tomorrow. We're gonna take a look at the video and a little bit of the backstory. As always, I'm sowing discord and discontent in the Telegram group because people have been noticing that Hauser hasn't been active on the Telegram group for very long, and they're getting kind of worried, especially with the handing down of this opinion. So now we're going to go back to where we were before. On Tuesday, which is the Roger Hillygus hearing. We still got about half an hour left to go. If we have any more time, we could take a look at some videos that have dropped that I haven't seen yet. But let's go ahead and take it there.
So this, Mr. Henty, you're acting like your own worst enemy. So those are my preliminary thoughts here. Let me hear from the state, please, on what they would have the court do, if anything. Then I'll hear from Mr. Silverberg, and then if you'd like me to hear directly from your client, Mr. Silverberg, on this issue, I will. When we're done with this piece, we're going to move to the state's motion for other act definitions. Okay, Mr. Stakey, your thoughts.
I would like to have marked an email from Mr. Henty to, among others, staff of the Sheriff's Department, the aforementioned people on the County Commission, representatives on the County commission as well as to Mr. Silverberg. I'll quote from it, and that it was forwarded to me.
What's the date, please?
April 26th, 2023, 11:38 a.m.
All right, so the next morning after the
Yeah.
commission meeting, right?
Yes. Various grievances, U.S. Attorney, Governor Quinn, Brian Sandoval, but reflecting on this court's concerns or the threatening nature of it, and I quote, "I'm not playing any more games with the corruption in the state. I lost everything and have nothing left to lose but my life. And after being a law enforcement officer for 30 years, I was never afraid to lose said life in the performance of my duties. And I'm not afraid to do so now, nor am I afraid of any of you folks in the legal profession here that are on a personal vendetta that all caps will."
Uh-oh. This sounds like Hanty's thing, because the letter sounded like it was a former law enforcement officer. I believe Hanty is a former sheriff, former deputy.
"Will be exposed one way or another, ... Trust me or don't on that aspect." I'd like to have this get an exhibit.
You may approach the court clerk. Mr.
Oh, he's a former chief.
Yes, sir. All right.
And so I reflect on the court's concerns about threats for how we got here. Unusual to have a gag order, very unusual. The hearing we had recently related to the question of violations, the contempt order. I reflect on two things. One, right, the court was rather restrained in its, right, as the court mentioned, restrained in its approach to the contempt. I don't know what else to do. I mean, the entire basis of this was related to contact with witnesses.
Tom, thank you for the gifted membership.
In the media, it is. I mean, this is a different case for the people who involved in it, because you have a former law enforcement officer saying he's not afraid to lose his life. That is, and and it's now right. It's moved on to the commissioner.
A little sussy.
Staff in the sheriff's office. I reflect also that sort of the second issue is I had suggested in my, I think, the original bail motion that we heard, this question of a mental health evaluation as a condition. Now, I don't need to know anything, so if the court were to follow my reasoning on that, I would suggest the court maybe order a mental health evaluation and that he comply with any, as a condition of probation, he comply with any recommendations. This sort of mercurial sort of up and down is, I think, potentially a cause for concern for the court. This idea that we have orders directing or prohibiting certain conduct, and that is, we keep coming back to it. So on that, I would underscore or highlight the state shares the court's concerns about sort of the tone of the public comment as well as emails.
Okay, give me just a moment. I'm going to hear from Mr. Silverberg. I just want to read the email again here.
So it sounds like he's reading the email that Hanty sent to the prosecutor.
I'll have this Exhibit 1 introduced as the purposes of this hearing.
Oh, really, Wade?
I mean, admitted for purposes of this hearing. You know, if the email had left out the part about I'm not afraid to lose my life now. You know, I wasn't afraid as a peace officer for 30 years, and I'm not afraid now. If that part weren't in there, it would be less indirectly concerning to the court, because it implies that Mr. Hanty is in a frame of mind where, you know, he's willing to do whatever it takes. I mean, that's just the undercurrent. What do you think, Mr. Silverberg?
Well, Your Honor, I don't think we can look at this in isolation. Of course, we have a history with Mr. Hanty, who speaks a certain way, very frankly, but his actions show that he's not intending anything violent. I guess.
Well, let me stop you there. Did you see the video? I mean, his body language, his aggressiveness, his tone suggested that
Yeah.
he
Yeah.
was one small spark away from snapping. Now, maybe
Uh-oh. Uh-oh. It looks like the judge has been watching some videos.
his motor runs in 2 speeds, fast and faster, and this is the way he lives his life. On the other hand, I'm trying to remember the last time somebody went to the Washington County Commission and identified judges that they had angst against, and with that type of tone, cadence, and using things like, if it's the last thing I do, I will stop it, guaranteed. And when the bell gets rung, I mean, what does that mean to you?
To me, what it means, again, in the entire context of the way Mr. Ante has proceeded in this case, is that he wants to expose what he believes are injustices in the system. And if it's the last thing he does, even if it relates to his freedom, because that's the way I read it, he's not afraid of the consequences that come by him exposing what he sees as corruption.
With the trial upcoming in 4 months, when there's already a partial gag order saying what he can say to whom about what?
Certainly,
And then he goes and identifies himself and his co-defendant and the judges that have had some piece to be involved in this? Isn't that a violation of his pretrial release? Shouldn't I revoke his pretrial release right now and set it for a...
So the judge is like calling him out. It's like, hey, when you went to the it sounds like he said this at like a county commissioners meeting where he made like a public comment. So that's okay. That makes sense now because I remember them mentioning a public comment. So it's not like he made these kinds of statements during public comment. The judge saw them and just like, talking about this is a direct violation of the gag order. So why shouldn't I revoke his pretrial release? So defense counsel's got a hole he's got to climb out of.
Johnston hearing in a couple of weeks to see what we can do to get him back on track?
I don't believe so, and here's why, Your Honor. What he's saying, again, I believe is strictly related to his passion about the case. He did not speak about any of the underlying facts of the case in this one. That's what got him in trouble last time, is he went on and actually spoke about the guardianship and the abuses and all that. No, that's not present here. It's a general expression of frustration and his belief in a system that is not treating him fairly. And does he have a way of saying it that could be alarming? I understand that. But, Your Honor, his actions show completely the opposite. He's done nothing but filing legal documents. He tries to file things on his own. And, he wants the system to work for him. I don't believe that there's an expression of violence.
Expression, how about undercurrent? How about veiled? How about camouflaged?
So I think if you were
if you're not able to hear it, the defense counsel is saying, well, he was only speaking in general terms at the meeting. He's like he's trying to put like a general, he's only speaking in generally about the court system and how he feels wronged by the system. He wasn't talking about the specifics of the case. Now the judge is like, well, I mean, yes, there may not be something explicit, but it seems like there's a little bit of an undercurrent, a camouflage, a veiled threats or threatening language that's in there.
In isolation, one might feel that way, but knowing how Mr. Ante has appeared before this court, always timely, always professional, and other than his mouth getting him in trouble, he hasn't done anything else, Your Honor. He hasn't. So is his tone of speech alarming? I understand that. I'm not as concerned because I've been here from the beginning, well, almost the beginning, with Mr. Ante. So I've seen how he is. I know he's passionate, but I haven't seen him take any action or be even close to taking any action against anybody in an inappropriate manner other than verbally lashing out. And I think he has done so. It's not my preference that he go speak this way. It's not, but I also have to understand that he has a right to speak. And he has a right to voice his frustration with the courts, with the prosecutor, with me. He's got. In this particular case, Your Honor, he did not, I don't believe he crossed the line of the court's gag order.
Either by the email or by what he said at the April 25th Board of County Commission meeting?
Right, because I don't believe he went into any of the facts of the case. It was more general expression of, hey, you know that you're certain people in this community, you know you're corrupt, and I'm going to expose them. And I think that's supported by the fact of his continued attempts to file pleadings before the court, to use the judicial system and its procedures to vindicate his rights. And he's done nothing of it.
Thank you. Mr. Steggy, final thoughts? Well, hold on a second. I said before, I give Mr. Hanty an opportunity to speak if his attorney thinks it's a good idea. Mr. Soderberg.
Against my advice, Mr. Hanty wants to make a brief statement.
Okay, just as to this issue.
Oh boy, here we go. Hey Sean, I did see that that uploaded on Law and Crime Network. We might watch that one. We'll see.
No.
Thank you, Judge. First and foremost, if when I put the uniform on for 30 years, I wasn't afraid to lose my life. If I was, I would never put it on to begin with. That is just a statement. Doesn't mean I'm going to go out there and do a Christopher Dorner thing. I would just say.
No, you don't. No, that's not how you. That's not how you do this, man. You don't start calling out names like that. No, it's not good. It's not good. Why do you mention? Oh.
Saying it. I've got to the point of frustration. You don't know this, the court doesn't know this, but there are entities out there that are surveilling me, tracking me based on what's around my ankle, and have been observed by other people other than myself. So I do have a little bit of concern.
Of course you're being surveilled. By you saying you have something stuck to your ankle, you're under house arrest. So of course you're being tracked. Of course you're being surveilled.
About that. I don't know who's doing it. I'd like to find out. I believe this gentleman here might know. But I did not speak on the merits of the case, nor will I speak on the merits of the case. That was your order, Judge. I followed your order.
Hey, facts and fraud.
No job in this world that I know of, the 63 years I've lived my life, is free of criticism. But as a cop for 30 years, I got criticized a lot. But I had to take it. And that's just part of life. So if people don't like the criticism, I mean, it's just like I just said, it's part of life. I am frustrated, I'm upset about, you know, the co-defendant here and myself having been brought into this situation. It bears mentioning to you, Judge, that my life has been turned upside down. I don't think that's fair. I don't think what the state has done against myself, Mr.
Well, look, now we're moving more towards.
But
You're putting into context what you said to the commission, and you're putting into
I did
context
not
that
threaten
email.
anybody with violence, nor would I threaten anybody with violence. That's.
But you need to choose your words differently, because your view of, I'm not threatening anybody, and the recipient's views might be different. You gotta know your audience too. When you use phrases like the ones the court has identified here, you know, to a lot of people, this court included, it seems to be you're right on the edge, if not got 1 foot over. And you want to stay away from that. You're a defendant in a pending criminal justice case. You're on pretrial release now, even though you've done things that directed this court to put you in jail from time to time. I don't want to put you in jail again. I don't want you to. You don't want to be put, but you're sort of digging yourself in, and you really need to knock it off. Find ways to, if you want to get your views out there, it shouldn't be directed at any person that's involved in this case. It shouldn't be in any way a threat to potential jurors, that if they ultimately decide this case in a way you don't like, that they have to be concerned.
And Judge, I've never tried the case in the media. They have, not me. The media does not want to talk to myself and Mr. Hillegas, so therefore it's a one-sided interpretation. I've never tried the case in the media. I'm just frustrated and angry. You're right. I run fast and faster. I did that for 30 years. I don't think I can ratchet that down. It's just been part of my life for 30 years. So if my faster is a little bit of concern to you, I'll ratchet it down. And
Please.
And that's my statement to you, Judge, and I promise I'll
Okay.
be good on that statement. Thank you.
Thank you. Any final thoughts, Mr. Steggy?
The pattern here is patent, right? From the inception, when we, in justice court, when we're talking about bail, it's pushing the line every time, you know. if, God forbid, violence happens, this is what we're going to point back to. I have no shock at all. I mean, he said it's not threatening. I mean, that's ludicrous. It's ludicrous to call, to say, I'm willing to lose my life over this. Right? I have nothing left but my life as not being threatening. I mean, it's transparent. And the idea, the idea that people act appropriately in court is of almost no value. Right? Because, I mean, it's the easiest thing to do, is the lowest standard of performance. Right? So, the court doesn't take action. Every time the court takes action, it works for a little bit, then it comes back. So there's really nothing else to say. The court should take action.
Doesn't sound like the court's going to take action.
Bottom line. The court is not finding you, Mr. Hanty, in violation of your pretrial release.
Yep.
I'm not revoking that. However, I'm going to give more thought to whether, and I'm allowed by statute, to modify the terms of your pretrial release, to add something, to require something, to limit something that I haven't yet thought of. So an order will issue if the court intends, based on this hearing, to further subscribe what you're allowed to do and what you're not allowed to do. But as of this moment, I'm not remanding you to the custody of the sheriff.
Oh my God.
So I strongly encourage you.
So the judge is giving him a stern talking to. So at least that's with Mr. Hanty.
To use better judgment, despite your frustrations.
Yeah, double secret
The
probation.
state has a motion to admit other act evidence with respect to Mr. Hanty. Now, just so I'm understanding what is being asked by this motion, does the state want, if it succeeds, to have an opportunity to discuss this and it's...
No. We're talking about, we're not talking about Hillegas. We're talking about Hanty. Hanty's currently under pretrial release. One of the conditions of his pretrial release is that he cannot talk about the specifics of the case in public. It's a partial gag order. But the state is calling him out, saying, hey, he was at this county commissioners meeting and was talking a bunch of BS about the case and making some vaguely threatening language inside of it. And so the state was like, hey, revoke his pretrial release. And the judge is like, well, they were mean words, but I'm not going to revoke his pretrial release. And he just said, do better next time. Why is Hillegas present for this? Because they're co-defendants. This hearing had issues to resolve with both Hillegas and Hanty, but they're being tried as co-defendants. Jennifer Lucas, thank you for the gift of membership. I appreciate it.
Opening statement, to introduce such evidence in its case in chief, to call witnesses to further these issues, or only bring it up in the event Mr. Hanty takes the stand and were to deny sophistication in the civil justice or administrative justice arena, or to deny that he has been involved as a peace officer in the criminal justice system. What exactly is the ask, and then tell me why I should do it.
So the ask is, so under bad act analysis or other act jurisprudence, if it's admitted, it would very often be admitted or mentioned in opening statements, right?
So admitted for all purposes.
Admitted, right, for Big Pond says for any relevant purpose. Now, as a matter of trial strategy, it's often the court probably sees where the other act that is admitted is rarely mentioned during opening statement, and it really sort of follows the flow of the evidence. So because the state currently intends to introduce the defendant's statement, right? That is our right to introduce the defendant's statement, sort of in which he, I like the court's words, sort of denies sophistication in sort of the civil realm. This makes the prior, his history of litigation in the civil context.
Okay, so the next part of this hearing, the next part is raising the. It sounds like the prosecutor wants to bring in some prior bad acts, into the trial. So, I'm not sure, Father. I'm not sure. But right here, he's trying to say that they want, and one of them sounds like Hanty's civil litigation that may be important here.
Relevant, right? Relevant, really this question of it's knowledge, right? Any claim of being duped, right, is belied by the fact of
That he knew or should have known.
yeah, knew or should have known, and given, I mean, above average, I would say, for a citizen's involvement in civil litigation, quite a number of cases involving civil litigation. And more precisely, the cases that involve garnishment, right, because that is this question of whether law enforcement enforces civil judgments, right? As a general principle, that does not happen. So, in this case, we have Mr. Hanty suggesting to or asking, police department to do something about this civil case, about this civil judgment. A thing he knows based on experience as a law enforcement officer, including having been the sheriff of the county, and his civil litigation experience, that does not happen, right? And in the narrow context that it does happen, the case he was involved in, the CB03 case, is you have an order that is directed from a district court judge to the sheriff of the county to say, enforce this order, garnishment being for one of those limited purposes. So should the court follow or grant the motion, I foresee, given the history, it's very likely that we'll see Mr. Hanty testify to sort of the years of law enforcement experience, but let's say he does not. I think that is still quite relevant, and really, and I would say that's gross in a gross context, meaning that the anticipated testimony would be rather brief, saying Mr. Hanty here's his history in law enforcement, working as a state trooper, working as a deputy sheriff, and working as a sheriff of a county, et cetera, including this aspect of while the sheriff of Mineral County, right, the special duties that come along with being a sheriff are the very limited context in which the sheriff enforces civil orders, but also that the sheriff, as party to lawsuits and in those narrow contexts where the sheriff does enforce orders, has seen what bogus pleadings look like and what real pleadings look like. That's the overall tenor.
All right, so it's got the prosecutor starting to put me to sleep, but it sounds to me like the prosecutor wants to bring in the civil actions that was going on that kind of precipitated the criminal action, which would be the mom's guardianship or something to that effect. And wants to bring that in, I believe, in order for relevance in this issue. I think that's what he's saying, but honestly, he's sounding so monotone. I'm losing. My attention span is already lost.
So a portion of the motion, ladies and gentlemen, the jury, he was a law enforcement officer. He knows or should have known what legitimate legal pleadings are like. This on its face is obviously bogus, therefore he ought not to have relied on it, right? His reliance on it is false, right? Or his statement that he relied on it is false. The second portion of it is his own individual participation in civil litigation. Again, I imagine this would be a broad strokes, the evidence would be broad strokes. He's been involved as a party to, I think it's 8,
My God.
a number of civil cases, and for purposes of this trial, I think the only one that would be relevant for the jury to hear about, I think it would be fair to say, he's been involved in 8 lawsuits, and I don't remember the exact number, let's say it's 8. He's been involved in 8 lawsuits as a litigant, and during that process, as a litigant, you see and are served with pleadings, which that would tell you what a true pleading looks like, as opposed to the bogus ones here.
Okay, so if I can, if I'm reading this right, he's saying that Hanty, with his law enforcement experience, would know, that would know what a proper pleading looks like, and would know what would be what would be appropriate to give to law enforcement or a sheriff's deputy for the purposes of enforcing a civil order, and that what he showed, for the purposes of the criminal trial that kind of got them in trouble, he would know that that was a bogus pleading or writ or order that was given to law enforcement in order to, or at least given to, I think, the nursing home, which I believe was the reason why for the kidnapping. If I could recall the facts of the kidnapping, what they did was that they drummed up some cockamamie order some vaguely judicial court order to the living home to get mom out of to get Hillegas' mom out of there. And I think what he's saying is that he wants to bring in these other bits of litigation to demonstrate that that Hanty knew what a proper writ or order looked like, and he would know that what he gave to the living home was obviously fake or fraudulent.
Second, so that's about as facial as it would get, and then the deep dive, or the most detail that the jury would hear, would be on the garnishment case, because it is so closely analogous and so goes to the heart of Hanty's intent. And Big Pond said it's not limited to the minute rule, but in broad strokes, I would say it's this question of intent and really lack of mistake, this idea of feeling duped, or this statement of suggestion that he was duped, undermines all of it and speaks to the true intent, which is to do it despite there being a real order, in the GR case, or GR out of Walker, right? His intent to do it against a true legitimate order on the subject.
Thank you. Mr. Silverberg.
Thank you, Your Honor. As outlined in my opposition, I think the first big problem, I think, with the state's motion is being a law enforcement officer, being involved in civil litigation, are not prior bad acts. It's not something that, at least in this courtroom, we don't see that as a bad thing. So I think that's the first big problem.
Well, let me ask you this. If I agree with that.
Well, which is true. But wait. So I would actually say, the defense. So, okay. Oh, let me gather my thoughts. So this is what was kind of, the defense attorney said what was going in my head, but it sounds to me like the prosecutors bringing up these prior litigation that Hanty was involved in, but it doesn't sound like they're prior bad acts. They're just simply other bits of litigation that Hanty was involved in to show that he's supposed to know he knows what a proper pleading, a proper order looks like. Not to disparage Hanty's character. And if the defense attorney agrees that it's not really evidence of bad character, then what's the problem of bringing these in? Because it's not to impinge bad character. It wouldn't violate the evidence rule. So I'm kind of curious as to what the defense attorney is going to say here.
Yeah. Then do I deem this denied because it's not what it purports to be motion? Or do I say, well, it's a motion in limine for sort of an advanced ruling before trial on evidence the state otherwise would seek to introduce?
Well,
Can we go that route?
I think since the state labeled its own motion as a prior bad act motion, it's appropriate to deny it on that basis.
Oh, okay. So that's it. So if the defense attorney argues that it's not prior bad act, and this is a misapplied motion, then the judge could actually deny it, saying this isn't even a prior bad act. So why are we having a motion to permit prior bad act evidence here in the first place?
If the state wants some advanced ruling on any of these other matters, then I would want an opportunity to respond in writing to that. I think it is, as Your Honor knows, as do I, because we've been involved in the civil world too. Civil litigation is extremely broad, and this brings up an issue that arises allegedly in the context of guardianship and orders. Nowhere in the state's motion is there anything showing that Mr. Hanty has some special knowledge in guardianships. If that were the case, might be a little bit tougher of a sell, but or tougher of an argument on my part, Your Honor, that it's not relevant. But dealing with garnishments has absolutely nothing to do with this. Nothing whatsoever. It's not a prior bad act. It's not relevant. If Mr. Hanty decides to take the stand and say, I've never seen a legal document before, well, then he's certainly opened the door for the state to cross-examine him. But as this stands as a motion for prior bad act, admission of prior bad act evidence, there is no prior bad act here, and it's completely irrelevant. And it's also extremely prejudicial because the state is trying to paint Mr. Hanty as some litigious person who should know better. And it's just not, it's not part of this case, it's not relevant, it's a huge stretch. So I would ask the court to deny this motion, and if the state wants an advanced ruling on the relevance of some of the other things that he's brought up that are not bad acts, but may be relevant depending on the testimony, then I think the state should make that motion, and I would file my opposition accordingly.
Okay, thank you. Mr. Steggy, briefly respond, please.
I don't understand that argument. The statute says other crimes, wrongs, or acts, right, that may have some character, sort of tone to them, can be admissible for non-propensity.
No crime, right?
Yeah, right, like,
Well, so, okay, so he says,
the idea that
Hold on. So crimes, wrongs, or acts?
so he's saying crimes, wrongs, or acts. Well, these aren't crimes. It's simply civil litigation. It's not wrong. As far as everybody else is known, Hanty is permitted to file civil litigation. There's nothing prohibiting him from doing that. So now it's an act. So I think it's the third one is the only thing that's going to satisfy this definition.
So these aren't crimes.
no,
They're not wrongs.
no,
They're other acts.
there are other
That
acts.
may be informative to the jury on the truth or lack thereof of any fact at issue in this case, right?
Yes,
The court has to, before the court were to allow some or all of what you're requesting in, the court follows the jurisprudence, the statute, finds that these acts occurred clearly convincingly, finds that they're relevant to the inquiry, and finds that their probative value is not substantially outweighed by the danger of unfair prejudice, right?
yes,
Now, you heard, among other things, first the defense says, Judge, don't let this in because, you know, we say, you know, bad acts as in usually substitute for criminal act, but the statute doesn't exactly require that. So I understand your argument, but the look of 8 possibly civil actions, it makes it look not just litigious, but it makes it look like Mr. Hanty's flawed, who gets sued or sues 8 times. That must be an imperfect human.
I mean, kind of fair. A little fair. I mean, honestly, look, the average human, the average person, even in a highly litigious country like the United States, the average person, like, is maybe the party of, what, 1, if any, lawsuit in most of their lives. I I mean, obviously it depends on your profession and what you do for a living and so on and so forth. But to be an actual party, granted, I was a party in a lawsuit long time ago. Don't want to talk about that, but it is what it is. It's a rare occurrence. So to be sued or be sued, to sue or be sued 8 times is a pretty substantial amount.
Somebody that can't find his or her way in the world, and they have to resort to the court. So that paints him out to be a bad guy. And then on the question of, as I understand the defense argument, his familiarity with legal process because of his peace officer background, that doesn't equate to he necessarily understood what guardianship type of official pleadings look like.
Which is also a fair point that the defense attorney raised, that just because Hanty is familiar with civil litigation doesn't necessarily mean that he knows how a guardianship order or guardianship pleading is supposed to be.
Are you saying that goes to the weight but not the admissibility, or something?
Yeah.
I'm not including class actions, Foster. I mean, if the number of parties involved is like you and maybe like 1 or 2 others at most. I'm not talking about class actions, because if we're talking about class actions, almost all of us are probably a part of a class action at some point in our lives, if not more than one.
That is one, right? That's a narrow interpretation of that. Now, of course, the court sees how that's dividing and conquering, right? Like, you can't have it be the case that you are a party to a civil case, a bunch of civil cases, right? But there's too many of them, and therefore, but as a law enforcement officer, you're not really involved with civil cases, therefore he's losing on both, right? That you can't have it be both ways. But to drill down a little bit, the CD03 case is a survivor's trust. It's a guardianship trustee case, right? It is so on point that it must be admitted. And the overall idea that, well, because the styling, it was styled wrong, right? These aren't really other crimes, therefore the court shouldn't even consider it. That doesn't really pass muster. The question is, how big is the character inference, right? The balancing is, how strong is the negative character inference that flows from having been involved in prior civil suits? I suggest it's not as strong as the court would suggest, right? Civil suits are rather common, right? What is the negative inference from being involved in civil suits? You're either wronged by somebody, and I don't even see that we would go that far, right? Whether he was the person wronged or sort of the injuring party in this case, I think it's not that strong. And even if that is the case, this is how bad acts analysis works in the jurisprudence on it, which is that character, whatever character inference, is that fairly prejudicial, right? And is it outweighed by its fairly relevant purpose? And the fairly relevant purpose here is, as stated, right? This idea that he tried to use his law enforcement experience to boost or endorse this bogus legal document as a basis to the feeling that he was duped into going there on a bogus legal document. That is entirely fair prejudicial. Fair prejudice comes from the relevance that, wait a minute, you say you're duped, but here there's strong evidence that you have been involved in litigation and you've seen what real, legitimate legal pleadings look like, including in a trust case, a case loosely in the same area of civil law. Now, yes, that's broad. That civil law is broad. That's a nice defense argument, but it doesn't preclude its admission, right? That's sort of narrow interpretation of it. The broad interpretation is you weren't duped. You knew it was illegitimate, and you therefore acted with the intent that the state described.
So I actually understand where the defense is coming from. I understand where the defense is coming from. It's like, hey, just because, you know, Handy's been a part of a couple of lawsuits doesn't mean he knows what every single pleading is supposed to look like. But I'm kind of siding with the prosecution here, because more than likely the guardianship, whatever paperwork they gave to the assisted living home was probably a SovCit, you know, screed that we all are well accustomed to seeing. And whereas Hanty, who if he's actually been a part of regular lawsuits, of like legitimate lawsuits, as in like before he went down the SovCit rabbit hole, then he would know what an actual pleading or an actual court order would look like. And it doesn't necessarily have to mean that it has to explicitly be a guardianship subject. It doesn't necessarily mean that his previous suits have to involve guardianships in order to make that assertion that he should know what a proper order or pleading looks like. Hey, what's up, our Nevada judges in the chat?
Right.
Shout out to you guys.
Knowing, with intent to commit a felony, knowing that you had no legal grounds to do so, that the grounds for doing so were emotional, not legal. And so now, so I think that is fairly.
I split. I don't know, man.
It's not really that act or other act.
I want to find a legal aid office
versus probative value, right? Because there isn't a strong character inference that flows from having been involved in civil litigation, unless we went.
So that depends. If they're 8, right? If they're 8, and I let you go to each one, that's different than if I say I'll allow.
It sounds like you need to get like an emergency filing. I would try to find like some legal aid office in your area. Sorry.
Litigation. That may be a way the court cuts that cookie.
Yeah, because that can happen in a variety of contexts, and although the scope of civil law is broad, he was represented in all of those instances. Fair inference that he himself saw the documents, and even, you know, in his capacity, although none of them really are in his capacity as a law enforcement officer, but one envisions a jury who doesn't know any better. If you're a law enforcement officer, you might be a type of person who gets, you know, served with lawsuits. More civil lawsuits might tend to flow from that line of work. So if the court just sees it as a prejudice versus probative, I like that analysis even better, because then the court's saying there's no real negative character inference flowing from having been involved in civil litigation. I think that's.
Well, I haven't made my mind up, of course. I have to think about it in light of these arguments, but I'm saying that might be.
Yeah, the court might say that's too many, but the court ought to allow the state with the most precision and the most detail to go into this trust case, because
I understand. You think that's the one that's as four-corner consistent with this case as any of them?
Yes, and to the extent that there are, you know, the allegation is that in that case that Hanty and Dozen sort of misused the trust. So I think there is room, and appropriate room, for the court to sort of sanitize, what's the word I'll use, right? Omit portions of that are too, that the character inference is too strong.
Understood.
I'm not here to throw dirt on him for having been involved in that. I would be here to say he's been involved in a case very analogous, right? Same area of law. In that case, a trust case, the sheriff, there's an order from the sheriff. He was served with that order. He knows what it looks like. Therefore, when he did this, it goes to show his truth.
I got it. Even though it's the state's motion and the burden, and Mr. Silverberg, if there's something that, based on this dialogue I just had with Mr. Steggy, that you'd like to respond to, tell me. If not, though, I'm going to have this matter submitted.
Yeah, Your Honor, I would just be repetitive. I think our opposition, what I've said already, addresses those issues.
Oh my God, it's almost over, guys.
All right, the matter's under submission. So here's where we are. We're going to conclude this hearing in just a moment. I'm going to see everyone back next week. I'm going to
Did you know that a judge takes a matter under advisement at the conclusion of a hearing to indicate that a decision is to be rendered at a later date? I mean, technically, I guess it means that, but it could also mean if a judge says I'll take that under advisement, it also means like your opinion has been noted and will be discarded. it's all it's all a way of just saying I don't give a damn what you say.
To see Mr. Hillegas and his standby counsel next week. The state brief to be followed by this Wednesday. State can respond at least a business day before. Make sure copies are emailed to chambers and to defense counsel. I'll make a decision on Mr. Hillegas' custody status. An order will issue directing that his next evaluation be in person. We have our June 12th, I believe, hearing on competency, which the court fully intends to make a decision one way or the other. So if the parties want the court to hear from witnesses, make sure they're subpoenaed and ready to go. Mr. Hanty's been reminded of the court's concerns on his email and also more directly comments he made and the tenor of the way he made them in front of the Board of County Commission, and the court reserved its right to impose additional term or condition of his pretrial release. I'm still thinking about that. And then under submission is the motion for admission of other acts of evidence that state just argued. Thank you, everyone. I wish you a nice afternoon. The court's in recess.
Thank you, Your Honor.
All rise.
I mean, honestly, I would tell you that retired colonel. I would tell you that referrals are probably the best way of getting good counsel. If I'm being honest, with you, what was the name of that site? What was it? Martindale. Martindale Hubble. Is the other Martindale Hubble is the other is the only site I've known that has at least a decent reputation. All right, let's all right, let's hear about this Rhode Island City Council member. Oh man. It was caught in his what was it? He was caught in his car, passed out.
Well, arrest is going to come check you out, man. I can't let you go. You were literally choking in your sleep. Somebody.
Oh, Jesus. I don't know. I don't know about this one, actually. It actually does kind of sound really rough. Let's go with a good old fashioned. I need something relatively quick. I'm actually kind of tired. That thing just freaking tired me out, actually. All right, we can go here.
Welcome to the Dummy Kruger channel, everyone. Today's video takes place on the
Good
hostile
old-fashioned Dummy Kruger.
waterways in Onalaska, Texas, where admiralty law has made its way onto land. Our
Naturally.
featured freedom fighter of the day, per him, isn't a sovereign citizen, but an American state national, which is totally not a made-up thing. Every once in a while, I come across a video that is so filled with idiocy, yet is somehow always entertaining to watch, especially after reading his description of the video. It reads, "I could have done better, but in the moment I was just trying to regurgitate years of watching YouTube." Well, buddy, that was your
Really? You're not supposed to admit that, man.
first problem. Could have been worse.
He said the quiet part out loud.
Yeah, I suppose so. Live to fight another day. Well, not in court you're not. Saying all that, let's take a look at how this accomplished YouTube viewer puts all of his hard work into action.
All right, we got emergency lights here. Hello, how you doing?
Hi.
I'm filming this. I'm just want to have our interaction documented. Do you have a body cam on?
My body camera's on.
You got body cams running? Can you check it and verify for me, please?
I know it's running. I can see the red light on.
Okay. What department are you with?
Onalaska PD.
Okay, Onalaska PD. What is your name, sir?
Sergeant Prince.
Sergeant Prince.
Yeah.
And do you have a badge number?
604.
604. Okay.
You pulled over because you don't have a license plate.
I figured that. I'm not driving.
Yeah, no, we're not
And
going to play the
this is-
sovereign citizen thing.
I'm not a sovereign citizen.
We're not going to do that.
I'm an American national.
Here's the deal.
All right, sorry. Already, I appreciate this, Sergeant. We're barely a minute in the traffic stop, and he already knows what's up. And not only does he say I'm not a sovereign citizen, I'm an American national. So, you know, first verse same as the first,
Ooh, bad luck for this American
or
state
second
national.
verse same as the first.
Whenever the officer on scene is already familiar with these nonsensical tactics, you know it's going to be a fun video.
I need a driver's license and a proof of insurance.
Okay. What can we talk about this?
I need a driver's license.
I'm not driving though. You see, I have it posted right here, not for hire.
He keeps putting up the window.
Sir, I don't want a problem with you.
I don't want a problem there.
But I mean, you're already coming off like hostile towards me.
I'm not.
He didn't seem that hostile. He's just, I like your license and proof of insurance. And told him the reason why he stopped you.
Your driver's
And he also said, I'm not doing the sovereign citizen thing. I don't remember him raising his voice at all. He seemed like a pretty flat.
license
I'm-
and a proof of insurance.
Okay. Can we talk about this? Because I have all the documents right here.
Driver's license
He does sound drunk, but I don't know if he's drunk, but he does sound drunk.
and a proof of insurance.
Okay.
He may also just be stupid.
Hold on. Am I stopped?
Yeah.
Okay.
Okay, maybe he might actually be drunk.
Can I get this paperwork here just to show you?
For anything in the vehicle.
I got paperwork here. I want to show you some paperwork.
You're not reaching for anything in the vehicle.
I'm reaching for this paperwork. That's all I'm reaching for, man. Settle down.
Been down this road before several times. I'm telling you.
Okay, what is it that you think that I'm wrong about what I'm saying?
Everything. Literally everything. You're not traveling, you are driving. American state national is not a thing. And whatever paperwork you're about to pull up will be wrong as well.
Your driver's license and a proof of insurance.
Listen, just hear me out. This is. So, can I talk?
Because I know what you're showing me. I've been
Okay, what is it that I'm wrong?
He's like, the comments I do, don't bother. We're not going no.
About what am I getting?
You're going to try and show me some excerpts from some case law that's not correct.
Okay, I love this. I love this. The cop knows exactly what the drill is. I appreciate it.
So here's the deal.
It's not what I'm showing you. That's not what I'm.
Driver's license and a proof of insurance.
That's not what I'm showing you.
Driver's license and a proof of
I'm literally showing you what the definition of driver means. It means one employed. I am not employed. I'm not for hire. I have it posted right here.
Black's Law Dictionary.
Not for hire.
Well, you buried the lead there. I didn't know you had this very legal piece of copy paper posted that you printed from home. My bad. Carry on.
No, I'm not refusing. I just want to talk casually with you. If we have to go down this road, we'll do it your way. Can we at least just...
Your driver's license, proof of insurance.
Sir, please just give me a minute.
Getting off on the wrong foot with this, you're going to walk yourself into a resisting arrest charge.
Dude, I'm already got a court case. I'm dealing with this.
Well, that sounds like it's not my problem, is what the sergeant should be saying.
I already have a court date. I'm dealing with this same thing.
Driver's license, proof of insurance.
I am not driving. I am traveling.
Driver's license, proof of insurance.
Why did he say that like he's a 12-year-old?
I'm not employed. It says employed right here. Coach, carriage, wagon, other vehicle, horse, animals.
Incorrect. That's not per. That is not per the Texas code for the definition for Texas.
What code book are you using?
It's called the Texas Transportation Code.
Right here. Look at 502. Can you bring your book?
I'm telling you, driver's license and insurance now.
No, I'm just saying. Look, you got this. This is the Texas. Man, hear me out, dude. Seriously, come on, man. Like you're being.
Driver's license, proof of insurance.
Dude, look. It says here.
Okay.
Dude, let me talk, man. You're not letting me talk. Why are you not letting me talk?
Because I don't have to let you talk when I've told you what I pulled you over for.
For what? You act like I did a crime. What crime did I commit?
You don't have a license plate.
That's not a crime.
Yes, it is.
No, it's not.
Texas says it is.
For what you have.
Is it a crime in Texas? It's a violation, and regardless of whether or not it's a crime or a violation, the cop is allowed to stop you and allowed to arrest you if you act up. So
Jurisdiction over. It is.
jurisdiction, drink.
You don't have a license plate on your vehicle.
Dude, you don't own the road.
He's right. This officer doesn't own the road. The people of Texas paid for these roads, and the people of Texas paid this officer to enforce the traffic code laid out by our legislators that the people from Texas voted into office. Questions? No? Good.
Can you send a supervisor?
I am supervisor.
You are the supervisor?
I am the manager.
So you don't got anybody over you?
No, my chief, she's at home. She's asleep.
So you're the only one I can deal with right now.
You're going to go to jail if you don't produce something. I'm telling you. Point blank.
But isn't the state law that I just have to give you a name?
No, you got to give me name, date of birth, or you got to give me a driver's license.
But I don't have to provide a physical document where I can just verbalize to you?
Name and date of birth.
I mean, yeah. You can write a name, date of birth, and run you through the system, but it's probably going to cite you for, failure to having a license? Failure to have a license?
So where I can run you, okay? Well, we're not going to do it. You're going to get a citation. If you don't sign the citation, then you're going to go to jail.
I know, man.
Which is also true, because in Texas, the signature on the citation is supposed to be in lieu of arrest. It's essentially your promise to appear. So if you don't sign it, you can be arrested.
But it's like, dude, this stuff takes up so much of my time. I'm already doing this with another county. I'm in Liberty County now.
Again, that's not the sergeant's problem.
Doing the same thing. I got the paperwork right here.
That's fine.
The fact that you're already dealing with a case similar to this isn't the officer's fault. That's a you problem there, buddy. Get your shit together.
Driver's license.
So do you think we don't have a right to travel? Is that...
Driver's license, proof of insurance. Point blank.
I don't have insurance.
Why am I not surprised?
Vehicle's coming with me.
Come on, dude. You really gonna do this to me like this?
Driver's license, proof of insurance.
I don't have insurance. I don't have insurance. So you're basically telling me you're gonna impound my car?
You have
Yep.
to have insurance. 100%.
Dude, that's not right, man.
Driver's license.
It's not right is you not having insurance, and then if you hit somebody, the person you hit is going to be on the hook. Because far be it from me, but I feel like you either don't have a job or you don't have the funds to pay for the damages.
I don't have proof of insurance. I don't have insurance. Dude, come on, man. This is the only car I got.
Then go get it insured or take a bus.
I didn't ask for you to drive without insurance.
True.
Do you pay for my insurance?
Do you have a job?
No, I don't.
Then that's not my problem.
There it is.
Buddy.
Oh man, this guy's getting wrecked so hard by this officer. I'm almost at the point of pulling for him.
I'm done. I'm trying to just be honest with you, my understanding of the law. It says one employed and conducting. And I look at, what does employed mean?
Here's the deal.
It says employed.
Here's the deal.
Contractor. What does contractor mean? Somebody who is under contract for payment. I'm not getting paid.
That is incorrect.
None of this is right.
Here's the deal. Open the door, get out.
I don't want to do that. I feel safe right here. I don't feel, dude, you're coming at me hostile. I don't know what you're going to
Open
do.
the door and get
Dude, you're freaking me out. I don't want to go outside. I'm safe in here.
All I've been hearing is the cop having an even tone of voice, but has been very firm. But he hasn't been shouting. He doesn't sound like, he's not like flailing all around. He's been telling you in a level but firm tone of voice what's going to happen, what he's asking for, and what are the consequences are if he doesn't comply.
I'm not safe with you. Here's
All right.
502-003, registration by political subdivision prohibited. So what this is basically saying is that a person who is not
Okay, so if I recall what he's trying to cite, he's trying to cite that the part of the Texas code that Rick Martin, constitutional lawyer who got hooked up for contempt up in Michigan. He's citing a part of the Texas code. All it says is that a political subdivision of Texas cannot issue licenses, driver's licenses, and registrations. The key indicator: political subdivision. Texas, the state of Texas, and is not a political subdivision of itself.
employed for commerce, like say if I was a bus driver or a taxi or doing Uber or something where I'm making my money on the road.
Okay.
They say if you're doing that, you're considered a driver. And that's the driver. If you look at Black Law Dictionary, what a driver is.
Black Law
here,
Dictionary.
legal definition. It says one employed.
Okay, listen, that's fine.
It's shocking to me that these guys are going to be cherry picking something, but the definition of employed per Black's Law Dictionary says it signifies both the act of doing a thing and the being under contractor orders to do it. That's two different things. You don't have to be paid to be employed to do something, at least per this 100-year-old book that you guys all seem to rely on.
If I give you a date of birth, will you let me go?
No.
So why am I gonna play that game when you already
Because you're gonna get arrested, and then you're gonna be taken to the jail, and they're gonna identify you one way or the other.
You're trying to take my car from me.
Listen, just answer his questions.
But he said he's gonna impound my car,
Listen.
and then he's gonna leave me with no car.
So vehicles come to me, he has no insurance, he has no way to identify the vehicle because he has no plates. Lance, listen. This is his stop.
I know, man. Come on, man. Let me make it, man. Let me make it.
Listen to me for a second, okay?
Pleading.
You're recording us, right?
Sure. You're recording me too, right?
I'm recording.
Everybody's recording. Everybody's
Okay,
recording.
listen.
What was your name and badge number?
Sergeant Land, Polk County Sheriff's Office, 815.
Okay, so now he's got a local sergeant, but now he's also got a sergeant with the sheriff's office. He's got two sergeants from two different departments.
Oh, you're Polk County?
Yes, I am.
And what is he?
He's City of Onalaska. Listen to me. I'm trying to explain this to you, okay?
I hear you.
So you can have all this recorded. This is his city, his jurisdiction. He's the sergeant in this city, okay? What he's saying is that due to you not having insurance on your vehicle, he's going to tow your vehicle, okay? You're not properly identifying with him. Now, you can be going to jail as well, okay? He's trying to work with you.
I know, but here's the thing. He's not. He's already
Oh my God, that accent though. Am I right?
told me he's going to impound my car. I'm trying to. What I wish to get out of this is to just get home.
Well, you probably shouldn't have taken advice from grifters and YouTube lawyers because going home, you are not.
What did I really do? What did I really do though? Like who's? Show me the victim here. Where's the victim?
There it is. I would count that as injured party. I'd count that on the bingo box. Injured party right there.
I'm already under arrest because I'm not free to go, right?
Nobody said anything that you
No,
about you being under arrest.
No, but I'm not free. Sir, am I free to go?
You're temporarily detained.
So no.
Detained.
So every stop is a custodial arrest. So right now, I'm under arrest. I want you to read me my rights now.
You're temporarily detained.
Read me my Miranda rights.
Well, I mean, that's the proper protocol, Deacon. I mean, it is the city cops stop. So protocol would be that he has jurisdiction over the matter.
Because I'm under arrest. Do what?
I think the sheriff's like pleading with him, don't do this, man, because I imagine the sheriff's deputy, the sergeant knows exactly what's about to happen.
Don't do this.
I mean, look, I understand at the end of the day, y'all could bust my window.
Correct.
Well,
y'all could drag me out, you could tase me.
Well,
You're a smart motherfucker. That's right.
I get it. This is y'all's world, and I got to deal with it. But all I'm trying to do is just be free, man. Is America free or not? Are we not free to travel?
oh, I'm sorry, this is America. Oh, I'm sorry, this is America. Like Randy Marsh getting put into the back of the cop car. Oh, I'm sorry, this is America.
Or are we not?
You are most welcome to travel between states. Lace up those Nikes and go right ahead. But if you want to drive on the roadways, you must abide by the traffic code.
You want to go home or you want to go to jail?
Man, I want to go home with my car. That's what I want. You trying to say you'll impound my car, but then you'll let me walk home or something?
Switch your vehicle off.
How am I going to go home?
Turn your vehicle off. Switch your vehicle off, Laz.
All right, y'all going to break my car? Just be honest with me, man. If y'all going to break my car,
Switch your vehicle off, Laz.
well, what are y'all going to do, man?
Laz, turn your vehicle off.
I mean, are y'all going to bust in my window? Just be honest with me, man. Are you going to bust it? Let me know if you're going to bust it. You going to bust it?
Laz.
Don't bust.
You thought she'd never find out. How well did that work out for you?
Oh, no.
Call the professionals at All Clear Auto Glass.
No, all right, cool. All right, cool. I'm stopping the video.
Oh, how convenient. Now
he stops the vehicle.
you're cool.
Man, I'm not moving. I'm not moving.
Yeah, I can see it.
I'm right here.
Don't move, okay? He's going to unbutton.
I'm right here. Look, hands are up.
Do not move.
I'm not moving.
See your arm.
Okay. I'm going to unplug my phone.
Go ahead.
Here.
Now lay your phone down.
Well, can I call my brothers and let them know you take me to jail?
Let this be a lesson to all of you don't you dare call me a sovereign citizen, and other scholarly YouTube spectators.
Yeah, you see that all the massive binder paperclip of paperwork that he has there.
This doesn't work. The fact that he saw a video of Paul Unslave's unhinged ramblings doesn't mean this entire farce is legit. In my opinion, the majority of police officers aren't beginning their day hoping they will come across a window that needs shattering. The recorded portion of the stop was approaching a half an hour, where we heard the officers literally beg and plead with this man not to go down this route.
30 minutes. 30 minutes in a traffic stop. I would say that's plenty of opportunity for the officers to get him to comply. So,
in theory, law enforcement agencies strive to apply the law equally and impartially to all individuals. The principle of equality before the law is a fundamental aspect of most legal systems and is intended to ensure that everyone is subject to the same legal standards and treatment. Have we witnessed times where this wasn't the case? Yes, absolutely we have. And I hope officers that don't apply the law equally face some type of punishment. However, upholding the traffic codes that say we are all required to have a driver's license, registration, and insurance should and is typically policed evenly across the 50 states. Because it's a pretty simple law. Okay guys, thank you everyone for coming by today. If you haven't had the chance to, please remember to subscribe, notify, like, and...
Shout out to Dummy Kruger for a great video. Definitely check him out if you haven't already. I mean, honestly, why haven't you already? But everybody, that's where I'm gonna end it here. I'm still still not really 100%. It's just been a really rough week. With work and everything. And other issues in the background. My parents, today's the 18th. My parents should be on their way home today or tomorrow. Probably today. From their Euro vacation. So, so yeah, that's where I'm at right now. We'll be streaming tomorrow again as to go over that Supreme Court opinion in Tennessee. I know there was something else. I could have sworn there was some other sovereign citizen related news to go through. But I forgot it. If I remember it, obviously we'll go over it on Friday. But I want to thank you guys again. Have a good night. Have a good weekend. Have a good night. And I will see you guys tomorrow. Oh, yeah. They want their food, or they want their evening snack. Yeah, I do want to do that again, Mickey. It's just that, my brother has been busy with work and, parental duties. So it's been a lot more difficult these days. I do want to get, my gaming channel will be revitalized as soon as I get that graphics card. Its delivery date has been updated to Monday. Not surprised. So if I get it on Monday, I'm probably going to stream on the gaming channel. Oh, see, you guys can see Archer right there in the camera. Archer. Anyway, I'm going to stream Resident Evil 4, the remake. That's been sitting in my hard drive for like the last 2 months, but I haven't touched it ever since I sent my card to get it replaced. So, anyway, guys, hit that like button on your way out. As always, thank you very much for being here. And I will see you next time. All right, take care, guys. Adios. Archer, what are you looking at? Fine.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine for my bitch a chew.